Hi, I'm DeSana, partner at Merrill Family Law, and today we're going to talk about non-marital assets. We're going to talk about the difference between marital and non-marital assets, ways to avoid commingling the two so as to protect your non-marital assets, and we're going to talk about prenups and postnups as a means of protecting your non-marital assets that might come up in the future and that currently exist right now. Okay, so the chief difference between marital and non-marital assets to remember is that virtually the default under Illinois law is that anything that you acquire during the time period when you're married is going to be considered a marital asset. And that includes your income and your contributions to your accounts, including your contributions to retirement, and gains that accrue on that property during the time that you're married. The other thing that's going to always be considered marital, unless you have a different sort of writing that says otherwise, which we'll get into later, is anything that's jointly titled. So if you purchased a house before you were married and you go on to add the other person to the title of that property, that's now going to be considered marital property generally. Non-marital property, the most classic example is non-marital property that was purchased or acquired prior to the marriage. So certain things like retirement accounts have both a marital and a non-marital value because you're able to secure the value it was on the day you got married because that was all accrued before you got married. However, as it continues to grow, that will be considered marital unless those gains are solely on the non-marital portion. We can talk about how to protect that later. And then the other thing that's going to be considered non-marital, there's certain exemptions under the law carved out. One would be a gift or an inheritance. That is a specific carve out. If you receive a gift or an inheritance during your marriage from a relative or somebody else, that is always going to be considered non-marital as long as you act to protect it by keeping it separate from marital property. There are certain things that I think traditionally people think of as non-marital property, such as lottery winnings or judgments in lawsuits. However, those are a little bit murkier. They're often favored in Illinois to be disproportionately shared to the person who received it, but it is not an automatic non-marital designation the way an inheritance or a gift is. So the best thing that you can do to protect your non-marital assets is to keep it entirely separate from your marital assets as best as you can. So for example, if you have an investment account that you had before you got married and you want to make sure that that account and its gains are going to preserve its non-marital value, the best thing you can do is not start mixing your income into that account, not mix other assets that might be commingled already or marital already into that account. Another thing would be that if you receive an inheritance account, if you receive an inheritance, a gift, a chunk of money that you'd like to ensure are protected and kept as your non-marital property, while you can temporarily place that into a joint checking or a marital account where your income goes into, if you're temporarily placing it in there as some sort of conduit to eventually put it into something else, that's generally going to be okay and it's going to be traceable. What Illinois law is looking for is whether that money is so clearly traced through the accounts. So the absolute simplest way is that even if you have to put it into a marital account for a moment, transfer it out into an account in your name and try to keep it almost dollar for dollar identical, the transfer. That's the best way to ensure that the money that you're putting separate is going to be considered traceable and that you will be able to prove to the court where it came from and that it came from a non-marital source. Another really important thing about making sure that you're protecting these inherited funds or other sources of non-marital income is to save your documentation of that. Save the documentation of when the inheritance accounts were closed, the will that dictated what you got. Those things are going to be very important later on if you end up having to defend that something was non-marital in court. And lastly, the best way to protect yourself if you are taking non-marital funds and contributing them to marital property. So this is an issue that we run into a lot where someone might have an inheritance, or they have a really large premarital account, or they have something that they're going to use to put down on a house. They're going to use it as a down payment. They're going to use it toward renovations. Renovations in particular can be really, really hard to trace. Absolutely want to do your best to make sure that whatever you're paying toward, it is coming from your separate account and that it's very clearly traceable toward that. The other thing to keep in consideration, which we'll talk about in a moment, is that often when you're giving this money to a marital property, such as a house, there is a chance it could be deemed a gift to the marital estate. And so you want to make sure that you protect that as well. So, like I said, often when you have non-marital property, even if you've been really, really good about keeping it separate, tracing it, if you're going to go ahead and put that money down on a house or on something else that's joint property and you do not presently have a prenup, the best way to ensure that that money is going to be protected and will not be considered a gift to the estate is to get a postnuptial agreement of some kind. And postnuptial agreements, especially for something this small, they don't necessarily have to be some really large document that dictates every single thing that's going to happen to all your property. But if you have something that's signed and notarized that dictates that this money was gifted to me and I am putting it down on the house and I do not intend it as a gift, I intend for it to be refunded in the event of a sale, that's going to cover your bases in the event of a divorce to prove that it wasn't a gift. However, the best thing that you can do to ensure that none of these things are really an issue as you go through your marriage and to protect yourself and your spouse and your future family from heavy divorce litigation is to get a prenuptial agreement in the first place. So many people are skeptical about even broaching the topic of a prenuptial agreement, but they are becoming more and more popular with people getting married nowadays. The thing to remember is that the best time to do one of these agreements is when you are getting married, because that's often when both people are going into it on at least relatively equal footing or closer footing than what often ends up happening during the course of a marriage after you have kids, someone backs off working, etc. These things are much harder to negotiate once bargaining power has been chipped away by one person. So if you're going into being married and you discuss having a prenup, you can pre-negotiate all of these types of things. You can secure that if one of you has an inheritance and you put down a down payment on the house, that is something that's going to come back to you. Or you can negotiate that it's not, or you can negotiate that only a certain percentage of it will be. There are all kinds of things we can do with prenups to ensure that assets are protected, but that any dissolution proceeding is going to end up being fair for both parties involved. Thank you so much for watching today. Again, my name is DeSana. I'm a partner here at Marital Family Law. And if you have any other questions, you can contact me at the number below or go to maritalfamilylaw.com to find out more. Thank you.